Hey everybody, long time no see. I tried to do it a little bit earlier today, so I'm hoping that a lot of people can still tune in. I think everyone's anxious to talk a little bit more about this response. Hi Eric, you're first. Okay, so just gonna give it a second. Yeah, I know that I was a little confusing in my post that I didn't say whether I was doing it on YouTube or doing it in the group. And the YouTube one yesterday was kind of just a trial run, so I don't know if I'll be doing more. I'm sure maybe somewhere down the line I will be. But like I said, the videos are mostly going to be in here. But if I do another YouTube one, I will make sure in the group to say that it's going to be on YouTube, and I will be giving you the link to the live stream so that you'll know. Since I'm still waiting for people, I did want to address one thing from the YouTube video yesterday. God, I have to stop saying that. You like it here better? Thanks. I do too. It's safe and it's comforting to me. I know, but I was trying to just make sure that I could reach more people with the information, because I knew a lot of people were asking questions, and that's why I really did it. The only thing I didn't realize, because it's a learning curve, is that I didn't realize that you can't comment in the chat once the stream is done. Or you can, but only for a couple minutes. And I didn't realize that. And I would have liked to have actually addressed a couple of things, or at least one thing. And I'm going to address it right now because I want to. That somebody in the chat, when I said something about all we had to go by was the 2 pages in the case report for the bones. And then somebody in the chat, was not going to let it go, that they had to correct me, that there's more than just that. And I believe said something even to the effect of, like some people should read more than just queso in the transcripts, which, come on, do you know me? So I should have been more clear, maybe, that I thought I made it pretty clear what I talk about and what I do. I'm talking about the motion. I was talking about a specific motion. And Justice was a little late today. She started barking just now, so she's a little slow today. But I was talking about the motion, and attached to the motion, the only thing about the bones is the 2-page CASO report. So when I'm discussing a motion, I am talking about it with respect to what the court is going to be looking at. And that includes the statutes and the case law, and it includes what's included with the motion. And so when I said that's all we have to go by, I mean that when we're guessing what the court's going to do with it, that's all we have to go by. We don't have all the information. The court doesn't have all the information we have. They don't have all the documentation that we have. Okay, so I just wanted to clarify that. Because, yeah, like I said, the person was very insistent that they needed to correct me because I was saying it wrong. And I was like, I don't mind being corrected. It's just that it wasn't really wrong from my point of view of what I was talking about and how I was presenting it. So I just wanted to clarify that. Okay, so, we got a fair amount of people on here. So, okay. Obviously, we got a hold of the state's response today. In a nutshell, it's garbage. It's complete garbage. It really is. Now, I need to do a disclaimer right from the beginning and say that the state's response doesn't necessarily have any bearing on how the court is going to rule. So if by early next week the court rules and they deny this, and you're like, why did you say the state's argument was garbage? Well, how the court rules doesn't change the fact that the state's argument is garbage. The court could have ruled without hearing from them at all. They don't need the state's input to make this decision. The Court of Appeals is going to make this decision based on the law. Okay, so this is not a situation where the state was required to respond or the court required to hear from them. They just wanted to get their 2 cents in. It was really the only reason for it. But they could present a crappy argument and it could still look like it rules in their favor, even though it really had nothing to do with them or what they said. So I just wanted to clarify that so that people aren't yelling at me about Hi, Jim. Like, why did you say it was terrible? Again, because it is. Now, I've taken a lot of heat over the last couple of years for being critical when Kathleen is a little iffy with her citations, okay? This is worse. This is actually worse. Now, what I said in I don't know, one of the previous videos, I've done too many of them lately to really be able to remember which one. But I said that when I look at something, my first thing is that I don't take anything at face value. I will usually give a very initial impression when people first, I gotta talk slower. When people first ask my opinion, I will give my initial reaction to it. That's just the first thing I think when I read it. It's not until I dig into it a little bit more that I really start developing a sense of how good or bad it is, or what's wrong with it, what's missing, how strong it is. All those things come later after I've dug into it a little bit more. The funny thing about this is that everybody's noticed by now, it's essentially a carbon copy of the one they filed in the motion to remand for the scientific testing. So a few key differences. And the one thing is that the Court of Appeals did rule on that. I don't believe we ever actually saw the actual order, because the Court of Appeals doesn't always give a reason. The state does cite a little bit of what they said in the order in here to try to make it sound good, but it's still not saying what they wanted to say. I think the best thing to do is I'm just going to kind of skim this and read some of it, and then I'll go over why it's such a problem. See? Justice. Say hi to everybody. Yeah, I know, you want your attention. She's not happy. She doesn't like the cold, so she can't go out and play. It's making her a little clingy and needy. Okay, so let me go back to the beginning here. This is going to be a challenge, I can tell already. Okay, let's see what they're saying here. They're saying that the issue that Avery claims he would like to pursue is not a specific issue related to Avery's, not Avery's, but related to the, Avery's prior Wisconsin statute 97406 petition. So, wow, how could I stumble that much over one sentence, Justice? You seriously need to move, because I have to hold it too far away and I lose my place. Okay, so they're saying that it's a new claim. Okay, he's saying it's a new claim and it's related to his desire to do scientific testing, which that has nothing to do with anything. Okay, this is not a motion that has anything to do with the scientific testing, other than the fact that this information was discovered because that motion was filed. Okay, and what they do a little bit in here, and it's kind of annoying, is that they try to compare it to the motion for scientific testing, okay, that they wanted to do. The remand that was asking for the scientific testing. Even though they're both motions to stay in remand, the situation, the circumstances are completely different, yet the state is trying to sell it as if it's the same thing. Oh, before I go any further, one of the other things I wanted to mention, and I'm seeing this a lot today, so I feel like I should explain this, is that a lot of people are complaining about the fact that the state didn't even address the issue about the bones. Well, they weren't supposed to. Okay, don't get worked up about it. They weren't supposed to. Okay, the issue in front of the court is a motion to stay the proceedings and remand. When Kathleen filed her motion, everything about the bones and about the violation, the constitutional violation, that is in the affidavits and the exhibits, that is all part of her argument saying why she should be granted this stay and remand. Okay, she's not asking for a decision on that. She's asking for a decision to stay and remand the proceedings. So when the state responds, they're responding to a motion to stay and remand. Okay, they're not responding to an issue about the bones. Okay, that's not even proper for them to address it at this point. It's annoying because we want to know what they have to say, but that's not the issue, you know, that they should be addressing, because it's not the issue that's in front of the court. It would actually be really off topic, really, for them to argue anything about that case. Once the case is remanded, then Kathleen is going to have to file another motion that is going to contain a lot of the same information that was contained in her remand or motion for remand. But when the state responds, then they have to address and respond to the specific motion, which in that case is the due process violation. That's where they'll address that. That's where they will address that. So don't get all worked up about them not bringing up the bones or mentioning it, because honestly, it's procedurally not even correct for them to do it right now, because that is not the motion in front of the court. This is only arguments for staying the proceedings and remanding it back to the circuit court. I need a drink, sorry. Mouth's really dry. Okay, so back to what I was stumbling over a minute ago. Okay, so what the state's doing is they're trying to act like this is the same type of situation. It's like they're saying it's apples to apples, but this is apples to, I don't even know if oranges is close enough. This is a completely different issue. Okay, the scientific testing was something that she wanted to do that may potentially have proven to be relevant to Steve's post-conviction proceedings. That is a big difference than something that is a violation of somebody's constitutional rights. Okay, big difference. Now, what the AAG said in the previous response was that the reason it wasn't allowed was because the 97407, which was the motion for scientific testing, is a separate statutory procedure. It's a separate procedural mechanism to bring another issue in front of the court. Now, if I'm being honest, when I read that one, I didn't even pay attention to anything else she said, or because I knew right away that she was right. Unfortunately, it happens every once in a while, but I mean, I knew she was right. I'm like, she's right. It is a separate procedural mechanism, and because of jurisdictional issues, like you can't have two separate proceedings in two separate courts, because only one court can have the record at a time. So I didn't stop reading. I just didn't pay a whole lot of attention. And if I would have known that this argument was garbage back then too. But unfortunately, as bad as that argument was, the one thing that was correct was that it was a separate procedural mechanism as far as the statutes go in order to do that testing. That's the only thing that was correct. Now, since the Court of Appeals, when they ruled, and this is towards the end, in this today's, or the one we just got today, in this response, is that they said it's not an issue specific to the petition in front of them. Okay, so I don't know if the state is thinking that they made a great argument and that's why the court ruled in their favor, or if they know it was garbage. And I don't really know what they're getting at, because even when they cited that, it's not helpful to their case at all. Okay, so I have to get back to this because I know I'm not going to remember everything that I wanted to mention about it. Just bear with me a little bit. Let's see, there's a prior request. He's asking to remand it to the circuit court. And they're complaining that staying this appeal would cause unnecessary delay. And I said that in some comments a couple days ago, and then I said it in the video yesterday. I'm like, they probably just want to whine about there being a delay. And since they did it last time, and yeah, they added that. Too. And then they brought up the whole ridiculousness. If he no longer wants to challenge the denial of the circuit court denying his post-conviction petition, he's welcome to drop it and he can pursue this new claim. Again, it's ridiculous. You know, he can't do that. If he does that, then he is procedurally barred from presenting any of the issues ever again. Okay, so the state really needs to stop saying that, and it's just a ridiculous thing for them to say. So, no, the 968, you talking about the preservation statute, Eric? He's asking, does a 968 fall under a 97406? Are you referring to the preservation statute? The statute, okay, I guess I have to make, I don't know. The statute itself, the preservation statute, doesn't fall under any specific, I mean, technically, yes. I mean, I guess if you're talking about a violation of it, you would bring it under a 97406. You could bring it under direct appeal too, so it's not the only way. But since a 97406 deals with constitutional issues, obviously if they violate that statute, you're going to say that they violated your rights, and so yeah, it would fall under that. But it's not the only way it can be brought. You can bring it under, like I said, a direct appeal as well. I think that's what you were asking me, I hope. Hi, Sandy. Okay, so I say that a lot too. I need to stop. So in their, like I said, in their previous one, they'd used kind of both those arguments where they had said that there was a separate procedural mechanism by statute and that under 808-075, which are actions that can happen pending appeal, it says that the Court of Appeals has the authority to remand a case back to the circuit court, whether on motion from one of the parties or on their own accord, they can do it for specific issues. What they act like in this motion throughout the entire thing is that the rule is that it has to be a specific issue regarding, that's contained in the petition. It doesn't say that. That's not what the statute says. Now, I think she's getting that idea, again, from what the Court of Appeals ruled last time when they said that it was not, it didn't pertain to the existing petition in front of them. But then even her own citation goes on to say, and they didn't give us good enough cause to remand it for any other reason. Okay, so even her own statute is kind of like going against what she's trying to get away with saying, but she brings it up several times. This is not regarding a specific issue within the appeal that's in front of them. And again, that's not what the statute says. So stop saying it. Drives me crazy. Instead, she's making this ridiculous argument that another, like, okay, back up. A 97406, I've talked about it repeatedly, its intention is to only be filed once. There are rules that you can, or there are exceptions to the rule that you can file another one in certain circumstances, newly discovered evidence being one of them. Okay, but in general, it's the intention is for you only to file it once. Again, in the interest of finality. Okay, so just like they're saying that the 97407, the testing was a completely new claim under a new, it had to be brought forth under a new statute. They're saying the same thing about this, and that's just not true. It can be filed under the circumstances they suggested if he wants to drop his current appeal, but those aren't the only reasons why it can be added. This is a constitutional claim that falls under 97406. It's the only way Steve can present it. He has a 97406 that is pending. And why would the court rule saying, nah, we get that we already have this in front of us and there's been no briefing or anything and we haven't decided anything, but still, nah, we're not going to let you include it. Even though the whole point of a 97406 is that you are supposed to raise constitutional claims or violations upon discovering them. So it doesn't even make sense. Logically, it makes no sense. And the state is trying to say, like, well, there needs to be some finality. How is it finality if you're going to go through this appeal for 2 years and then start the whole process over again? I'm pretty sure the Court of Appeals is just as sick of this as all the rest of us are. Okay, they don't want to, I mean, it's actually not engaging any sort of finality into the procedure. It's actually lengthening it. Okay, it's actually the opposite of what the state is saying that it will do. And that's why I said that. It's like, it's a nonsensical argument. It doesn't even make sense at all. Now, one of the reasons I said that the court could deny it is if they say that it won't be procedurally waived or procedurally barred if she wants to present it later. But again, then why postpone it at all? And I really love how the state goes on explaining, well, you can file this again. Oh, we know there's that potential waiver issue, but don't worry about that. It's not up to the state to decide. They act like Kathleen had no right to file this motion. Well, she absolutely has to worry about it being waived if she doesn't present it. If the court tells her, we would prefer you file this under a different claim after we've concluded these proceedings, okay, then at least she knows she's not barred from presenting it. But the state doesn't get to decide that. They can just decide on their own that you're not barred. Because if she would have done that, the first argument the state would have made is that he's procedurally barred from making this claim because he's filed a previous 97406. So again, it's a stupid argument for them to even make. Because it's just, it doesn't make any sense. That is the problem. And this is why I have said that, it demands a remand, because why would you just hold off when you already have a petition, which is where this claim belongs, in front of you? No, they don't have this exact claim in front of them, but they have the procedural mechanism in front of them where this needs to be addressed, which is exact opposite of what they said last time. And again, they're trying to make it sound like it's the same thing. No, whether this is a new claim or not, it's the same procedural mechanism. It's not a different mechanism like the 97407 was. Okay, so it's a very big difference. And I don't know, gosh, I'm not even going to address some of this because it's so bad. There was even this is where she brings up 808.075, subsection 5 and 6. And again, she says that it's up to the court's discretion. Well, how about we just leave it to them then? And you stop trying to make stupid arguments, okay? She also has to point out, and this is where I'm like, okay, just stop being childish on top of it. It's bad enough you already made the ridiculous claim, like, you can drop it and we'll be happy, and we'll be fine with that. It's bad enough you're saying that. But when she had to put in parentheses, using the word may in respect to this court's authority to remand. Is she 12? Seriously. I don't like it when people insult my intelligence. I can imagine how the court feels when they see something like that. I'm pretty sure they probably hate her. I'm just saying. So they mentioned that she's bringing the argument under Youngblood. And then she says this claim is just as far afield from the issues in this appeal as the claim underlying the previous request. No, it's not. It's being brought under, again, the procedural mechanism it needs to be brought under, which is currently in front of the court. I do not get this woman's reasoning at all. And then she even says that, because she calls it a new action, she says that Avery asked this court to stay his appeal and remand his case to the circuit court so he can litigate a new 97406 motion. And then she puts in the footnotes, well, he doesn't explicitly state this. However, the only procedural mechanism for raising a constitutional due process claim is under a 97406. Yes, which we have one happening right now. It's stupid to say, well, he's saying he'd have to bring it under a new one. First off, not allowed. You can't have two of them pending at the same time. And on top of that, you're only supposed to have one to begin with. What is she saying? My God. And then it just gets better. Okay, so she goes into a little bit about case law that just talks about the procedural bar issue. Okay, and again, even she's like, well, if he's ruled as, if the court rules that he's barred, well, then he's barred. And again, it's like, well, yeah, but let's let the court decide that. Why are you saying that? You can just present it later. Okay, so this is where I really just lose my mind. No, I haven't lost my mind yet. This is where I really lose my mind. It says, this is exactly, I'm reading this verbatim here. As explained in the state's most recent response, which was the last one, and I'm sorry I didn't read this, it really focused on this last time. opposing Avery's most recent remand motion in all of the published cases addressing staying an appeal and remanding to the circuit court for additional proceedings. First off, not all of them, okay? It's not all the published cases. The remand to address a specific issue related to the claims already to address a specific issue. Okay, I'm starting over, sorry. The remand was to address a specific issue related to the claims already before the Court of Appeals. I'm saying it again because it's very important. She is saying the remand was to address a specific issue related to the claims already before the Court of Appeals. And then she cites 3 cases. She cites Farm, Yang, and the commitment of Matthew. And actually, Farm and Matthew are both civil commitment cases, okay? Now, let me go over to my notes about that. Okay, so for Yang, now she puts in the footnote for Yang, she writes a footnote and says that this motion was granted, but then later rescinded. Okay, she's leaving a lot out. Okay, it's kind of the most important thing. Let's see, okay. So Yang, despite what she's saying, never presented this claim that he's asking to remand the case for in his post-conviction motion. Never, it was not in front of the court, okay? It was not in the circuit court when they ruled on his post-conviction motion. So therefore, when he appealed the decision, it was not in front of the Court of Appeals. Hello, lie. Okay, what happened in Yang was that the Court of Appeals, while the case was pending, ruled on a decision in another case. Yang thought that decision was relevant to something that happened in his case. So he asked for a remand based on newly discovered evidence. Whose side is this citation supposed to be helping? Okay, anyway. He filed a motion to remand based on newly discovered evidence in order to file this claim that was related to this most recent decision. And the court granted it. That's the important part. Okay, what happened after that was that the court in that other ruling had a change of heart, and they withdrew that opinion and reissued it. And with the new ruling, it would not help Yang in the way that he thought it would. And even then, okay, they said, we are going to rescind the remand. We are not going to send it back down to the court, but we're going to let you add this claim to your reply brief. Huh? It's crazy. I mean, this was never ruled on in the circuit court at all. And maybe they just felt bad because they said they were going to remand it and then they didn't, but they still let him present the claim. But again, the key point here is that despite what the state is saying, this case was absolutely not in front of, this claim was not in front of the Court of Appeals when it was granted a remand on newly discovered evidence, no less. Go figure. And again, the first thing I thought was like, this case helps Kathleen more than it helps the state. Where are they getting this from? And again, all they said was that it was already in front of the Court of Appeals, and then in a footnote they said, well, it was later rescinded. So they're trying to present it as a case, well, yeah, they originally granted it, but they changed their mind. They're changing their mind had nothing to do with the statute that says they had the right to remand it at all. Okay, so then we get to Farm. And again, as I said before, this was a civil commitment petition. And that falls under a 980 proceeding. Who cares, right? Okay, so there's a whole proceeding you have to go through if you're going to civilly commit somebody. Prior to the actual hearing, Farm filed a motion to dismiss, saying that it was the petition to commit him was improperly filed or untimely filed, whatever. The court denied his post-conviction or his petition to dismiss. So that went to the Court of Appeals. They went through with the commitment proceeding. He was civilly committed. He decided he was going to appeal the decision to dismiss the petition. And he just decided to throw in to his brief for a motion for summary reversal some ineffective assistance of counsel claims. He hadn't presented them in the circuit court at all. So technically they were in front of the Court of Appeals, but improperly. The only thing that was really in front of the court for consideration was the motion to dismiss the petition for the civil commitment. That's it. The IAC claim was not in front of the courts for consideration. It just happened to be mentioned in the brief improperly. So what did the court do? Did they say you're out of luck? You didn't file in the circuit court? No. They remanded it back to this trial court so that he could present this new claim, these new IAC claims, in an amended post-conviction motion. Again, who does that sound like it helps more? And then Matthews, same type of situation. Okay. In this case, the only thing different is that when Matthews, it was a civil commitment proceeding. Once he was committed, he filed an appeal. And then here's what it says about that. In reviewing the matter, this is in the Court of Appeals now, in reviewing the matter, Matthews' new attorney concluded that there were ineffective assistance of counsel issues that needed to be addressed in the circuit court. Matthews' attorney filed a motion to stay the appeal and remand the case to the trial court for further proceedings on the IAC claims. Separate claims, not claims already in front of the Court of Appeals. And then it said, this court stayed the appeal and remanded the matter to the circuit court. Do you see why I said this garbage? You know, you were seriously citing things that are actually helping the other side. Because all of them, first of all, you flat out lied. You said that all of these remanded the case on issues that were already under the Court of Appeals consideration. Lie. None of them were. Every single circumstance were issues, claims under the same procedural mechanism that they wanted to add as they discovered them. And they were allowed to do so. Now, when I said that there is actually, when I said she also was not correct, I won't say lie. She was misinformed that those are the only cases cited or published. There is, and hopefully, oh, by the way, Kathleen can file a reply to this, and trust me, based on that, she better. If I don't see all those exact arguments against those citations, I'll be angry. Plus, I better see a citation for State versus Redmond. Remember, State versus Redmond, where the reason you don't see a lot of cases citing this is because it's a right, well, it's not a right, but it's something that is allowable under statute. The statute allows for it. So you don't need a lot of case law telling you you can do it or telling the court they can do it because it's allowed under statute at their discretion. But what they said in Redmond was that if a defendant wants to assert additional grounds for relief that have not been addressed through the original post-conviction motion, he can petition this court to remand to the trial court for consideration on those specific issues. So again, and they just cite the statute. So again, it's just case law that's just basically citing the statute. But again, the state is trying to act like she can't even do this. She can't bring this. She can't, she's not allowed to do this. Well, literally everything goes against that statement. Of course she's allowed to do it. That's what it's meant for. And then right here in Redmond, they just spell it out for you. Or they just say that you can petition the court to ask for a remand for any issues that were not presented in the original post-conviction motion. And again, the difference is that you're talking about a constitutional claim that would need to be filed under the motion that's in front of them. Not a separate issue under a separate statute that doesn't have any definitive way of possibly helping. A civil rights violation is a civil rights violation. Okay, so there are actually a couple unpublished per curiam opinions, which is unfortunate. But just like I said that the state can't cite Dodge if they're going to want to fight the preservation statute, Kathleen can't cite these. But I still thought they were interesting, but because again, it's still indicative of how multiple courts have felt on, or rule on this issue, even though it can't be cited in any cases. And again, the reason it's probably unpublished is because it's under statute. You don't really need to spell it out for anybody. But in State versus Kabagwa, this is not necessarily on point exactly, but still, it says that in a supplemental motion for post-conviction relief, he asserted that after filing his 97406, he obtained new evidence in the form of a medical report. And according to him, this new evidence would have impacted the post-conviction court's decision on the motion as originally filed. So in this case, the newly discovered evidence would still apply to the decision-making process on the original petition. So it's not exactly on point. But again, it's still a situation where they'll remand it for newly discovered evidence. Oh gosh, okay. And then in State versus Gladney, which this is exactly on point. Again, unpublished, can't cite it. It says that the circuit court denied a post-conviction motion. While the appeal was pending, Gladney moved for remand to the circuit court on the grounds of newly discovered evidence. Now, this is the best part to me, even though I wish you could cite it, but you can't. To facilitate the consideration of all of his claims together, we granted the motion to remand. After a hearing, the circuit court denied the motion for a new trial based on the newly discovered evidence, but that claim is now before us in addition to everything else that was already pending, which is exactly what would happen in this case, and that's why I'm saying they have to do it. Why would you go through a whole separate proceeding as opposed to just getting this issue in under the same appeal? And yet the state's trying to claim that it promotes judicial finality. It does the opposite. It just lengthens it, prolongs it. So this is actually very short in comparison to most of my, this is really all I have to say on the issue. So I'll just take any other questions if anybody has any, because to me it's so cut and dry. But again, I cannot say enough that this response really has no bearing on how the court will decide. The court's going to decide based on the statute. And again, though, for all the reasons I said, it makes no sense for them to deny this at all. It makes no sense at all. So I know, I mean, I will never say I guarantee something because, hello, it's the courts. They can do anything. And I've stopped trying to completely predict what they're going to do. But it really would be questionable if they denied this. It really would be. Okay, now I'm going to scroll down and see. No, the Court of Appeals has not responded yet with regards to that. I think I mentioned this before, that in general, it's one judge. It's a 3-judge panel, but one judge is the motions judge for the court, for the district, for the Court of Appeals. In District 2, usually the judges rotate who's going to be motions judge. Sometimes it's weekly, bi-weekly, could be monthly, whatever. That judge has the authority to decide that motion on their own. If he decides that he wants more input, then he can refer it to the full panel. And then they make the decision, and a majority decision would win. So if that happens, that can take a little longer. Also, the Court of Appeals for District 2 is in the Waukesha County Courthouse. The Waukesha County Courthouse was closed for all court activities yesterday and today. Now, again, especially if it's just one judge deciding, he could probably do it on his own and submit it, but if it's all 3 of them, they'd probably wait until they're back in their offices before they do anything. And again, they might have still gone into their offices because they're dedicated public employees. I don't know. I'm just saying it's possible that the weather could have set them back a little bit in this situation because their offices are in a courthouse that has been closed for the last 2 days. So, and I understand, like in some of the jurisdictions that it said that employees were supposed to report. It actually doesn't say that for Waukesha, but judges don't qualify. As long, and considering that the chief judge is actually in this district, if she's like, we're not coming into work in this cold, nobody has to. Sorry, just doesn't happen. So yeah, so we could get a ruling tomorrow. It might not be till next week. Don't know. There's no set time limit, but again, they're going to want to keep this moving. They don't want to stall unless they need more time, but they shouldn't. Uh, 968 appeal. No, that's not for a criminal proceeding. Is that like temporary, like parental right, termination of present? I don't even know when that is. I'd have to look. Yeah, the 968. No, all criminal appeals fall under 90. Wow, totally just lost it. Don't mind me. I just totally lost it. 90702. There we go. I just got my numbers all transposed in my head. A 90702 would be the initial post-conviction motion you can file immediately after sentencing, when the attorneys say, I am, informing the court of my intention to pursue post-conviction relief. That is the first opportunity to challenge your conviction. If that fails, then you can file a direct appeal under 80930. And then if that fails, then you can do what's called a collateral attack. You can either file a habeas petition on IAC claims in the appellate court, or you can file a 97406. And obviously people have filed multiple petitions, but that's not their intention. You either have to have truly newly discovered evidence, or you have to provide sufficient reason as to why it was not presented earlier. You see, the 968 itself doesn't fall. Again, if you're talking about the preservation statute, it doesn't fall under. I mean, it's just that it's if a violation of it should constitute a constitutional violation. Remember, there is no remedy, and the courts have never given one. So even though Kathleen is saying, we're saying, we all believe that it should be a civil rights violation if they destroy evidence, that has never actually been determined by a court of law, and it's not in the statute. So it's not a bright line rule as far as a due process violation. I know, crazy. Okay, I'm just looking through the rest of the questions. Will the court see how stupid and deceiving she is? Yes, probably. They'll probably notice, but like I said, it won't have any bearing one way or the other. And this is the same, this is the same AAG. Back when she was first put on the case, when they got rid of Castle, who actually knew the case and knew the law, when they first put her on there, she filed in opposition to the motion to supplement the CD, because she said that they were trying to supplement something that was, and they wanted to present a new Brady violation that was not in front of the Court of Appeals. Well, in that case, she was wrong, because the Brady violation actually already was in front of the Court of Appeals. The CD was to supplement the record because it pertained to that already existing Brady violation, but she completely misstated it. So yeah, I love this AAG, I really do. It just doesn't matter what she says on these motions. I hope when she files a brief that it's this bad. I really do. The references I just made, I was talking about the case law that was cited by the state in the motion. You'll have to go back and watch. I can't go through it all again. So, the 2 to 3 remand motions. Okay, sorry, I shouldn't be laughing. People, actually, you're not the first one to ask. Obviously, the motion. We know, like, the last one was denied, okay, and it was remanded. It was remanded back for the issue with the CD. The first one is what people haven't been able to figure out. Technically, it was the motion to hold in abeyance the original pro se appeal when she requested to do the scientific testing. The only problem is she didn't know it was a motion to stay until the state told her that it was. And that sounds terrible, I know, but it wasn't. It's actually, I don't know, I find it kind of funny because I see humor in weird things. But yeah, I'm assuming that somewhere in Illinois law there's something that's a statute on hold and abeyance, because there isn't in Wisconsin law. So when she filed that, the state was basically like, do you mean a motion to stay? Yeah, there's a statute for that. And so that is technically what she's referring to, even though it was never called a motion to stay, but it was the same effect. It was holding, staying the appeal until she could present the motion in the circuit court. And that was her first motion, really, so I'm sure she learned. But I'm surprised how many people were confused by that. But yeah, I was like, so technically that's what she's referring to. It was not called a motion to stay, but it was the same thing. Yes, it's still Judge Angela. And now somebody had asked if we can replace her yet. No. The only way you can replace her is if for some reason, now if, yeah, I mean, there really still isn't, because no matter what, it's gonna be remanded on limited remand. The intention is going to be that whatever the outcome of this proceeding is, it's still going to be appealed. And if you are adding it to this existing petition, then it's still under the jurisdiction of the Court of Appeals in this current appeal. And there would still be no remitter filed about there being any finality to this appeal. So until there's some sort of finality to this appeal, we're stuck with her. And if there is a hearing granted, which should be, if Steve wins, the state will appeal. It will be consolidated as a cross appeal, because now it's the state that's going to be appealing a ruling that's in favor of Steve. If Steve loses after the hearing, it will be consolidated just as part of Kathleen's current appeal. Most likely. I think that's how they would handle it. I don't see why they'd handle it any differently. I know, Wisconsin law doesn't make sense. Well, it doesn't help when you have lawyers that don't make any sense out of it either. Okay. So for the brief, I know some people were saying like, well, we don't know. Technically, they still have the due date. I think they do. Can anybody confirm that? I didn't actually look if they still have the due date as the first. Normally, when you file a motion like this, it tolls the time for when the brief is due. So however many days before the due date she filed this motion, once the motion is decided, actually it's really going to probably only be in the case of denial, they will usually then tack on that many days. They will just toll that time until after the briefing schedule resumes. Now, last time they gave her 35 days, but I think that was after the whole entire remand and everything. So that could be why they gave her more time. But that's usually how it works. But honestly, it's up to the court. The court could just set whatever due they want, but it won't be due. It won't be due right away. I mean, if it was a denial, if they're going to deny it tomorrow, well then they might, and they wouldn't be due tomorrow. But again, they might not give her as much time. With her math. Will it be a circuit court judge, Angela, or an appeals judge making the decision? Sorry for the stupid question. It's not a stupid question. I'm not sure which one you're asking about, though. The motion to stay in remand obviously will be done by the Court of Appeals. If it's remanded back to the circuit court and there's a hearing involved, then that would be Judge Suckwitz, and she would decide after a hearing, she would decide whether there was a due process violation or not. Can you appeal a ruling on if they deny a hearing? Well, yeah, then, I mean, that's what they did with the first petition. They denied Steve a hearing on the original petition for post-conviction relief, and that's what's being appealed. So I'm thinking you probably didn't mean to ask that. Are you meaning that, can they appeal this denial of a motion to stay? That's probably what you're asking. Technically, yeah, but she'd never do it. It's not something that's just really done. It's extremely rare, and the courts don't like it at all. So, I mean, it's one of those things that, well, technically she could, but it's almost never done. Why can't the state and the judge realize that the fight for our guys is totally appropriate and reasonable? Boggles your mind. Try living here. You'll see. Again, I've mentioned this several times. Unfortunately, the state of Wisconsin is just not as willing to believe in these guys' innocence as other places are. That's the problem. You know, minds change. I mean, minds are changing. I think there are definitely a lot more people that believe they're innocent. And even, I'll take anybody that just believes they deserve a fair trial. I'll take that too, because that's a new trial. There are a lot more than there used to be, but it still pales in comparison to the numbers in other places that are other countries, other states, and even compared to how many people still believe that the guys are guilty. The motion to stay and remand. Yeah, that's decided by the Court of Appeals. But like I said, a motions judge would consider it first, which is one of the judges in the Court of Appeals. They just rotate which one is going to handle it. Motions are always considered by one judge, and he only refers it to the full panel if he's got a question that he's just like, I'm just not sure what to do with this. Then he'll ask others. So anything else? Any other questions? I'm sure I'll think of something as soon as I get off the air. I feel like I'm going to be suffering from too much exposure. I've done so many videos, but there's just something every day, it seems like. And of course, when there's a ruling, unless it's a denial, well, even if it's a denial, I don't know if I'd do another video because they don't usually give much of an explanation. So there's not much to talk about. I've kind of already explained why they could deny it, but I just don't think they will. I've been wrong before. So I don't know. It doesn't make any sense to me. Jennifer. Good night. Okay, so anything else? Any other questions? I think I covered it pretty thoroughly. The key points basically were they didn't discuss the bones because that's not what the motion's about. They have to respond to the motion in front of them. The state responded to the motion to stay and remand. Their case law is all faulty. They're misquoting statute or misrepresenting the statute. It's not a separate statutory procedural mechanism. It's the same one. It's just a new claim under it. Do I think Casey is here nearing the end of her investigation? I think I talked about this once before. Her investigation is never going to be officially done until Steve's out. There really is no end until then. And even honestly, even after he's out, because they still would have a wrongful conviction suit to prepare for. So there'd still be more investigation. So yeah, it's not going to be done for a long time. Kathleen doesn't need to reply to the response, but I said she should. I mean, even though she's not going to tell the court anything they don't already know, just for this year's sake of just telling them that they're idiots, I would do it. That would be my reply. This is too stupid to reply to. Sorry. Stop talking. That would be my reply. So again, though, the only thing that's bad about it is that I wish the decision was based on the strength of their argument. And their argument really has nothing to do with what the court's going to decide or their reasonings for deciding it. Okay, so I think that's it. Yep, okay, so I'm going to wrap it up. And I'm pretty sure I'll see you guys soon, one way or the other. Night.